To commence proceedings, we are privileged to hear from two remarkable keynote speakers whose work embodies the principles of justice and inclusivity that we seek to promote. Our first speaker is the Honorable Chief Justice of Bangladesh, Syed Rafat Ahmed. It is a great honor to welcome the Honorable Chief Justice of Bangladesh with us today. We are truly grateful that His Excellency has taken the time to be here, given the recent political events in Bangladesh, and share his thoughts on these developments, as well as on the country's ongoing journey in the field of justice. His Excellency, the floor is yours.
Excellencies, distinguished guests, participants, ladies and gentlemen, good morning. As we convene this conference, the notion of sanctity of justice comes foremost to mind, given the recent student-led revolution in Bangladesh. The people's will has been expressed through a collective voice, demanding accountability in governance and thereby underscoring the crucial role of an independent judiciary in achieving just societies. The quest for justice in Asia and the Pacific is a story woven through centuries, a narrative marked by both progress and pain. The legacy of colonialism has cast a long shadow imposing foreign legal frameworks that often disregarded indigenous practices and customs. This resulted in the alienation of many communities from their own systems of justice and fostered a legacy of inequality that continues to impact the present day. We see a growing demand for a reimagined justice system respecting diversity, prioritizing inclusivity, and empowering individuals to participate in the pursuit of justice as active agents of change. Western liberal individualist ideology is seen by many in Asia as informing the Universal Declaration of Human Rights and the two international covenants as representing an individualist ideology that should be revisited and reviewed in the Asian context. An alternate ideological base is found in the propagation of Asian values that have emerged from the Asian experience in state building and economic development. The Asian perception of human rights is accordingly said to be inextricably linked with economic development, harmony, national unity, and autonomy. My view is that a pragmatic approach should be taken of a gradual accommodation of universal democratic and human rights principles within the Asian socio-political culture. The Asian experience indeed shows that the achievement of such harmony and stability appears to hinge on the empowerment of the individual to a greater extent than previously deemed feasible. The empowerment of the individual becomes key towards strengthening community bonds and spearheading advancements at the community level. Bangladesh provides an instructive case study of the pursuit of inclusive justice within the Asia-Pacific region. The country's diverse socioeconomic circumstances, political landscape, and cultural context underscore the imperative for tailored approaches to guarantee justice for all. In Bangladesh, village courts have revitalized the historical tradition of community-based justice, significantly enhancing access to legal remedies at the grassroots level. We have also made significant progress in improving access to legal aid. The provision of legal aid represents a vital instrument for empowering those who are unable to pursue justice due to an array of constraints. In that sense, the scope of access to legal aid in Bangladesh has expanded beyond its initial focus on addressing financial limitations. In order to address the broader spectrum of barriers to justice, the Supreme Court has introduced a scheme similar to the capability approach. This innovative framework extends beyond the mere financial incapacity of individuals in order to encompass other obstacles that impede their ability to secure legal representation. One other promising approach to reform is the establishment of community-based legal aid programs through the diversionary mode of delivery of justice. I cite here in particular the efforts of one of our subordinate court judges who, as a dedicated district legal aid officer, worked tirelessly to bring justice to the doorstep of those often overlooked by traditional legal systems. Recognizing the importance of addressing issues at their source, he personally visited the sites of the disputes, For land-related conflicts, for example, he collaborated with an expert land surveyor from the Assistant Commissioner's Office, ensuring that mediation meetings were held on site. As he organized these mediation sessions, he understood that true justice extended beyond mere resolution. It required community involvement. Therefore, he arranged awareness programs alongside the mediation meetings, engaging local residents and elites to foster understanding of their rights and the legal processes available to them. After each mediation meeting, he took the initiative to hold follow-up awareness sessions. These sessions were designed to ensure that the knowledge of legal rights and services permeated every level of society and community. Furthermore, he reached out to local NGOs, journalists, lawyers, and educational institutions, conducting awareness programs that inform community members about their legal entitlements. Through his unwavering dedication and innovation approach, he transformed the landscape of legal aid in that particular district, creating an informal justice delivery system that was effective, cost-free, and free from harassment. Ladies and gentlemen, we all recognize that systemic inequities, which are deeply embedded within the social structure, serve to perpetuate cycles of disadvantage. The disparities faced by marginalized communities, defined by factors such as economic status, ethnicity, or gender, therefore, require due attention. In Bangladesh, public interest litigation, or PIL, aided by judicial activism, has emerged as a powerful tool for addressing social, ecological, health, and other connecting concerns about governance and holding concerned authorities accountable. Collectively, these cases illustrate too how PIL can serve as a catalyst for progressive policy making. Indeed, a spate of such cases involving sustainable development and environmental degradation and environmental justice emerged eventually as a precursor to a constitutional provision dealing specifically with protection and improvement of the environment and biodiversity. Incorporating the principle of intergenerational equity in environmental law, Article 18A of the Bangladesh Constitution, that makes the present generation the trustees of future generations, has informed judicial thinking and pronouncements significantly. Institutional reform, ladies and gentlemen, is not merely a social requirement. Rather, it is an existential imperative that demands immediate action. My office in recent months has laid out a roadmap for reforming the justice sector in Bangladesh. At the core of these proposed reforms is the necessity to safeguard the independence of the judiciary from external influence in order to uphold the rule of law. It cannot be gainsaid that the establishment of an autonomous and impartial judiciary is essential for the advancement of constitutionalism, the protection of the rule of law, and the sustenance of democratic governance. The UN Basic Principles on the Independence of the Judiciary employs terminologies such as influences, pressures, and interference as antithetical to the independence of judiciary. Indeed, these factors determine the extent to which the judiciary may act impartially, free of bias, prejudice, fear, and extrajudicial compulsions and constraints. The independence of the judiciary is also a crucial element in the articulation of a limited form of government, whereby the government itself is constrained by the Constitution. It becomes imperative to appreciate here the relationship between the sovereign state and the sovereign people in the context of people being recognized in the ultimate analysis as the legitimate source of the state's powers. In this sense, a constitution can be considered as a compact or a social contract between the people and the government, establishing the government as a limited authority subject to specific conditions. The Constitution serves to safeguard individual liberties, thereby protecting individuals from encroachments by the government or other parties. That ideal constitutional structuring of the three organs of the state, that is the executive, legislature, and the judiciary, is imagined to operate as a system of checks and balances with an overarching aim of separation of power. The judiciary, as a crucial and independent component of such state apparatus, serves as a counter-majoritarian institution, thereby maintaining the separation of powers and ensuring the accountability of the executive and legislative branches. In the aftermath of the student-led July Revolution, the Supreme Court of Bangladesh has taken significant steps to safeguard the independence of the judiciary. The Supreme Court has submitted a proposal to the government to establish a separate secretariat aimed at ensuring interference-free judicial administration. Another notable achievement has been the validation of a ruling that nullified the 16th constitutional amendment to the Constitution of Bangladesh. This amendment sought to vest the authority to remove Supreme Court judges in parliamentarians, a move that was deemed unconstitutional. Consequently, the authority has been reconferred upon the Supreme Judicial Council, an in-house body comprising of the Chief Justice and the next most senior judges of the Appellate Division of the Supreme Court. It is similarly of great importance to establish transparent and well-defined procedures for the appointment of judges. As part of the reform scheme, the objective is to establish transparent and merit-based criteria that ensure the selection of judges, thereby reinforcing public confidence in the judiciary. Furthermore, as part of the reform scheme, there is an intention to digitize the judiciary in order to meet the evolving needs of a technology-oriented, globalized world and to enhance both accessibility and efficiency. This will facilitate greater engagement with the legal system of citizens and ensure the timely resolution of cases. It is equally our objective to ensure the training and education of lawyers and judges and to engage them in comparative studies of judicial systems, thereby bringing about necessary reforms based on best practices and innovative solutions that have proven to be effective in other comparable contexts. To that end, we are setting up the Bangladesh Supreme Court Research Institute in Cox's Bazar, located in southeastern Bangladesh. In that regard as well, regional legal forums can function as a conduit for the exchange of experiences, the identification of shared challenges, and the formulation of collective strategies to enhance access to justice. In this connection, I want to cite here the example of the South Asia Judicial Conference on Environment and Climate Change held in Dhaka in 2016, organized by the Supreme Court of Bangladesh, which emphasized the importance of regional cooperation in addressing environmental justice issues. This conference exemplified how regional legal forums can serve as vital platforms for sharing experiences and formulating collective strategies. In conclusion, I reiterate that it is incumbent upon us to adopt a people-centered approach to the rule of law, thereby ensuring that our policies, laws, and institutions are equipped to uphold the fundamental tenets of the social contract I earlier spoke of. Let us therefore resolutely commit ourselves to these ideals as we labor in unison to build a more just and equitable society where the people remain the final arbiters of government,